Good morning, ladies and gentlemen, or afternoon for the seven counterparts. up on the lovely Gold Coast, albeit it's raining today. My name is Jason Bettles. Welcome to our final presentation, Worrells specific presentation for the year, where we're going to chat about mitigating your risk, advisors under fire. And we're going back a little bit pre-COVID. Every November, we used to give you some interesting stories that happened during the year. But of course, during COVID, where the government was giving out all sorts of money and nobody could sue anybody, the insolvency sort of dropped off a little bit. And so we didn't have as interesting stories to sort of present to you. But we're going back, and this whole presentation is about some of the more interesting files that we've handled during the year. But we're going to give you some top tips that we come out from each file. So hopefully you get a little bit of a takeaway from them. We'll start with, of course, our standard disclaimer slide, and of which I'm calling an apology. And I'm calling it an apology because I sometimes get a little bit carried away in some of these stories. I might tell you a bad dad joke. Maybe I'll be not quite so PC or not quite so woke. And also, I tend to waffle just a little bit and get a little bit sidetracked along the way. So I'm going to apologize up front for all of that. If you've got any problems, you misunderstand anything, please feel free to put a question in the chat, albeit that they're not necessarily files that or stories that sort of necessarily have any questions. We've got 5 stories to chat about today, albeit one of my apology things is I've never actually said the 5th story. I've presented this a couple of times and I've only managed to get on to through to 4. So as I say, I waffle on sometimes a little bit and get a bit sidetracked. So we'll see how we go today, whether we get on to the 5th story. Our first one is about a builder who thought he just had the most genius plan in the world to protect his assets, but the rest of us just call it a phoenix. We're going to talk about the security company where, well, they just did the opposite of the builder and they pretty much ignored everybody, but we got there in the end. DPNs and repayment plans, they don't really mix, and we'll have a bit of a chat about how they don't mix and what are the problems from there. The 4th story, Needle in the Haystack, is about a transfer that occurred quite a number of years ago, but ultimately was found out in the end to be against creditors' wishes. And story 5, the deregistration that never was, a story about director penalty notices and deregistered companies, and how there seems to be the light at the end of the tunnel to fix that problem. So right, let's get on to story number 1 or file number 1. And as I say, these are real files that that our offices right around the country have handled during the year. Now, construction. It always seems to lead the list of industries that are in financial difficulty, and I haven't quite figured out whether that's because there are more construction companies than any other out there, or whether it's just that builders aren't particularly good with dealing with their money, or perhaps there's something systemically wrong with the industry and payments. But this is a story about a company that was a residential builder, had been operating for about 14 years prior to the company going into liquidation, so certainly had some experience in building. But as is always the case, there's always sort of one file, one construction that you sort of have some problems with, or at least one. And in this circumstance is no different. There was a residential build, a bunch of things went wrong. Ultimately, there was a falling out between the homeowner and the building company, and the contract was terminated, and the homeowner sued the builder for the rectification works and to finish off the contract. Sued for about $500,000, so a reasonable sort of sum of money, which ultimately the company lost. And it probably didn't help the company's defence to the matter when in the witness box, the director made this statement about, Your Honour, everybody makes mistakes, and this one got through, made it to the end. It's not the first mistake that we've ever made, and it probably won't be the last. I think faced with that evidence, the judge had no choice but to grant an order in favour of the homeowner. So they've got a judgment of $500,000 with the company. What the homeowner didn't know was that after the homeowner had commenced the proceedings to sue the company, The director had come up with a fantastic plan, or what he thought it was a fantastic plan, to sell the company business across to his son. He didn't directly say this to the other side during the proceedings, although he intimated there was some correspondence saying, oh, look, you may win, but you'll never get anything out of us, and things like that. Ultimately, the homeowners got the judgment. The director thinks, oh, this is great. The business has sort of continued on in the future with my son, and told the homeowner, well, you're not going to get anything. The homeowner persisted and ultimately had the company put into liquidation. And that's where we come into the picture. So we've been appointed the liquidators by the court. In respect of liquidations, in a lot of cases, the director's not particularly happy that their company's in liquidation, blames the liquidator, and is not very helpful in providing us with information. Now, that's the general rule. There's, of course, a whole bunch of exceptions where the director is very helpful during the process. Unfortunately, this wasn't one of them. We start by asking for all of the records of the company. We require the director to complete a form that sets out the assets and the liabilities of the company. This director responded to our request for information saying that, oh, look, the company's got no records. Sort of a little strange considering the company's been around for 14 years. See, I know it's a building company. What you're suggesting, there's never been an invoice issued to the company, or the company's never issued an invoice onto somebody else? Clearly wrong. We're sort of a little bit used to this, and that's unfortunately not an uncommon scenario. So we keep sort of persisting. At some point, the directors got some advice and realized, well, that's probably just a bit of a silly answer. So it comes back to it and says, look, sorry, sort of got that wrong just a little bit. Company's got lots of records, and look, I promise I'll get them delivered up to you, which the director never did. And we kept persisting, asking for the records. Ultimately, we got correspondence for solicitors for the director saying, yes, director's got lots of records, but there's some pretty private information in there. So we claim, well, the director claims legal professional privilege over all the records, and we're happy to deliver that up to you, liquidator, but only on the basis that you give us these undertakings that you're not going to reveal the records to anybody and things of that nature. Now, this is sort of not really how the system works. We're the liquidators, we're in control of the company. If anybody's going to claim legal professional privilege over something, it would be us, and the director can't really claim that in respect of the company's affairs. And you certainly can't say, oh, these are company records, but I'm not going to give it to you, liquidator, unless you promise to do something. No, the law says you've got to give them to us. So we're still at this stalemate, still trying to get the sort of the physical records and some physical information from the director. What the director didn't know is that in the background, the accountant is very, very helpful and gives us access to the Xero. So sends us out one of those invitations. And so now we've got access to the computing accounting system. Of course, we can do searches with banks and get copies of the bank statements. So we've got a bunch of information in the background, despite the director not helping us whatsoever at all. So really great that the accountant was prepared to help us, although as the story goes on, one wonders whether the accountant sort of thought better of that later on. What we did find out from the information that we'd attained was that there had apparently been a sale of the company's business to the son's company. Okay, that's the director's son, for about $1 million, just over $1 million. But the son hadn't physically paid the $1 million. It had just appeared in the financial, on the Xero, as a loan. Son owes the company $1 million for the business that he has purchased. And through a wonderful creative accounting at its best, the loan has managed to get cleared out of the company's records through a dividend to shareholders. Now, I'm not going to bore you with all of the details. We've got some lawyers on the call, and I start talking about journal entries, their eyes will glaze over and they'll switch off. Just work with me on the basis that started out that there was appeared as a loan to the company, and then the loan just disappeared out of there. So now the business is across at the son, and the son's apparently paid for it. But of course, there's been no physical money changing hands. So all that has occurred in the record is a series of journal entries to make things appear and then disappear. And probably really the big thing out of that is the concept came up with by the director. And so he's put himself into a bit of a position there, but now he's dragged his son into it by involving this sham sale to the son. And one of the shareholders was the director's wife. So he's also dragged the wife into what is really now a deception to keep the assets away from the creditors. So we report all of this out to creditors and say to creditors, well, we still don't have a whole bunch of records to perhaps link the story together. This is how we think that it looks, but we need more information. We need some evidence. And the director is not being very helpful. And we asked if creditors were interested in funding a public examination. So public examination is a power under the legislation for the liquidator. And in fact, there's a few other parties that have the power as well to approach the court to ask that various parties be subpoenaed to come up and answer questions under oath in front of the court, and also requiring parties to deliver up records. So the homeowner who, as I said, was successful in a claim for $500,000 was more than happy to fund the costs of doing that public examination. So we summoned up the director, the accountant, the wife, the son, and required the delivery of all of the records that they were holding back on us. We knew we were going well when on day one of the public examination, counsel for the director sort of mentioned, councils sort of have their little chats in the background. The counsel for the director suggested that the position of his client wasn't particularly great. So we sort of knew, okay, we're on to sort of something here. One of the things we've learned over the years with public examinations is there's really not a lot of point to examining the party that has started the story or started the lie. So in this case, the director, maybe the bankrupt. Really what you want to do is examine other parties who sort of have nothing to lose, I suppose, in providing the evidence, because generally the director will stick to the story that they've told you all the way along. We do examine them just to get it under oath, how they answer the various questions. But we're interested to see what the other parties sort of had. As you can see from the side there, the wife and the son apparently knew very little about it whatsoever at all. This is despite the son buying a business and now running a construction business, and the wife receiving a fairly hefty dividend somewhere along the line. The accountant was very, very helpful, albeit that the information that he provided perhaps ultimately led a little bit to his downfall, because the accountant admitted that they had backdated the whole transaction to defeat creditors, to keep the assets away from the creditors. In fact, the accountant admitted that they would have backdated it further, but the tax returns and the financial statements had been done for a previous financial year, and they thought it was going a step too far by going back even further, because that meant that they had to then adjust the tax returns and the financials. I think it was a step too far doing the backdating in the first place, but apparently it's really a big step too far to go back even further than that. So the accountant has told us how the stories worked, that the director had come up with the idea that he'd been involved in doing this backdating to transfer this asset onto somebody else from there. So, of course, armed with that information, well, we basically sued everybody. The director, the wife, the son, the accountant, the accountant's firm, all for participating in what is essentially a breach of the director's duty to transfer this asset away from the benefit of creditors. The defense from the director, the wife, and the son was pretty messy, probably because there really was no defense. They said that, look, it's pretty normal in business to backdate things. They may go through people's heads and they may actually do it, but I don't know that you really want to put that in writing. And they blamed the accountant. Well, we just took advice from the accountant. The accountant's advice was to do all of this. And so we followed that. So in our view, it's normal commercial practice that we took advice from, clearly pointing the finger at the director. None of that is one thing that we commonly see through our insolvency administrations. It's always the advisor's fault. Oh, they told me to do it. When you know that the reality was The director came with a problem and convinced the accountant or the advisor to assist them in trying to keep assets away from creditors. Ultimately, we didn't get to an end on the litigation. It's settled at mediation, a confidential settlement, so I can't sort of tell you who paid what to whom. I can tell you, though, that the accountant had to fork out a fair bit of money, as well as the other parties. So the accountant certainly didn't get away with anything in the ultimately at the end of the story. So some top tips, some things to think about. I know we all want to help our clients. And I suspect that whilst I tell you the story and it clearly sort of paints a picture of this accountant being intricately involved and had done the wrong thing along the way, I'm sure as you went through the story in real life, it probably didn't appear as obvious to the accountant about what was happening on. But at some point, the accountant should have stopped and said, look, I can't do these journal entries to make up something to backdate things. So don't help your clients do bad things. At some point, you've got to sort of put your feet in the sand and stop and say, no, I'm just not being involved with this at all. I repeat, the directors always blame the advisors, whether that's the accountants or the lawyers, they're always blaming them, trying to shift the blame onto something like that. An interesting part about the public examination was that the director turned up with a lawyer and a barrister, but none of the other parties turned up with them. Like the wife didn't have one, the son didn't have one, and neither did the accountant. And from you as advisors' perspectives, whilst public examination is ultimately a place where the liquidator is just trying to get information, there's no outcome, there's no judgment that comes out of a public examination. It's just us trying to ascertain information. And so, even though that's the case, we'll always recommend you turn up with a lawyer, even if you think the questions are going to be fairly simple. In this case, the accountant has turned up and admitted to backdating things with a view to defeating creditors, to keeping assets away from creditors. So he's said some pretty serious things and has said those in the stand without the benefit of a lawyer, without the benefit of legal advice. So my suggestion is, even though it's probably going to have to be something that you're going to pay for personally, that you may not be able to recover from the director, from the other parties, turn up with a lawyer. If you're having to go to court and answer questions, turn up with a lawyer. Now, I don't know whether or when the accountant told the professional indemnity insurer. I can't imagine that a director who's turned up to a public examination without the lawyer has bothered to tell the professional indemnity insurer, which makes it for a really awkward conversation to tell your PI insurer after you've gone and said these terrible things in the court case, and saying, oh, I'm now being sued, so I'd like to make a claim. It's going to be pretty awkward, I would have thought, with a professional indemnity insurer. So if you think you're caught in something like that, or that you know that the director is blaming you, might want to inform the professional indemnity insurer, and they'll probably give you a big Queen Street law firm to turn up to public examinations with. So just a little suggestion from there. But an interesting story that we had, and clearly was what we would call an illegal phoenix. Ultimately, there was a return to creditors, which is great. So some of the money came back, but perhaps the director shouldn't have gone down there in the first place. A second administration is about a security company. I'm going to call the director Biff. Biff did completely the opposite to our builder. Biff didn't try and move the assets away. Biff just stuck his head in the sand and said, "Oh, if I do this, surely the problem will go away." He did this old ostrich theory, and it's all to do with an $11,000 payroll tax for the Victorian OSR. Yeah, none of us really like taxes, and probably payroll tax is one of the ones that we like the least. And that may be what was going through sort of Biff's head. Biff's managed to ignore the invoice from the Victorian Office of State Revenue. He's managed to ignore the follow-ups. Maybe there was a phone call. Certainly would have been some sort of demand, letters from a lawyer, a statutory demand, and ultimately a winding up application. Biff's managed to ignore all of those. Ultimately, Biff's company is put into liquidation, and that's where we come in. Another court-appointed liquidator. Um, and so Biff really ignored our initial attempts to contact him and really only paid attention when we froze the company's bank account. It really sort of focuses people's attention when suddenly you don't have any money. And Biff was very quickly on the phone to us at that point about what's this liquidation about. And is often the case, the directors dispute the debt. And in this case, disputed that owed the Victorian Office of State Revenue any money. Biff said, we haven't operated in Victoria for quite a number of years. We just operate in New South Wales, so we don't owe the Victorian OSR any money at all. As I've said earlier, then turned around and blamed the accountant. Said I'd left this with the accountant to sort out. The accountant was sorting out. Turns out Biff was overseas when the winding up application occurred, having a great time on holidays. And in his mind, the accountant should have fixed it up and didn't fix it out. And he knew nothing, and it's all very unfair. It's always unfair when your company gets wound up in these circumstances, apparently, despite the fact that you've ignored a hell of a lot to get to this point. Biff suggested, well, look, it's $11,000 and you've frozen my bank account. Look, I'll just ring up OSR, I'll get the payment details, I'll just pay them the $11,000 and this can all be done. Unfortunately, that's not how it works. Once the court appoints us as the liquidator, the only person that can remove us as the liquidator is the court. So yeah, great, go ahead and pay the $11,000. That is part of the process, but still you're going to require an application to the court. So you can't just pay the debt. You have to do a number of things. Paying that original debt is one thing, but there's a number of other debts that come along from that. It's the OSR's cost to make the court application. There's now liquidation costs as we're investigating the affairs from there. You'll need to engage lawyers to make your own application to court. The court will want some view from the liquidator, so we'll now need to do some more work, and we'll need to have a lawyer as well. And basically you're going to have to prove to the court that the company is solvent and that it was all a big mistake from there. I don't know how the judges view it, but I can imagine that they're perhaps not the most amenable to your request to get them their company back. So of course the judge would be wondering, well, you've spent a whole bunch of our time just to put it into liquidation, and now you want to spend a whole bunch of time getting out. But unfortunately, these scenarios are not uncommon. This is not the first one we've seen, won't be the last. We've seen sort of quite a few along the journey. But anyway, you've got to go through that process. In terms of assets of a company or the business of the company, what we discovered was $118,000 in the bank account. So it's not in a circumstance where the director doesn't have the $11,000 to pay. He just didn't want to pay it, didn't believe he owed it, so just ignored it. They had a photocopier on lease. The photocopier company just wanted to know if someone was going to keep making the monthly payments or should they come and collect the photocopier. It's a security company. It did have one contract at the time that we were appointed, and that actually was with the New South Wales government providing some security services. The liquidation provided a breach or a termination clause inside of the agreement, so the New South Wales government terminated the security contract with the company. I understand, or I suspect, that the director arranged for the actual security guards that were sort of doing the security work just to invoice the company, invoice the New South Wales government direct. So I don't think there was a disruption to the services, but certainly now the company's in a position where it's in liquidation. It has no ongoing business, a bunch of money in a bank account, and perhaps a photocopier from there. So not complex affairs, but certainly the director is a little unhappy with the position. Now, if there's one thing that the director did great out of this, after ignoring everybody in the early days, he did get onto a lawyer very quickly. In fact, he got onto a lawyer recommended to him by the accountant, the very accountant he blamed for this whole sort of scenario in the first place. That lawyer had some experience in this area. In that regard, it's not a really niche area, but some exposure to insolvency law would be very helpful to make this process of applying for the liquidation to be terminated smooth. I've seen it, and this is an example of one where it worked very, very well, but I've also seen ones where the lawyers wasn't very experienced in the area and there ended up being delays. And ultimately, the delays were so great that there was little point seeking to terminate the liquidation. So finding a lawyer with some experience or some knowledge in this area is a very important part of the process. The lawyer was onto us very quickly. Within sort of a week of the appointment, the lawyer had got in contact with us, told that they were immediately making the court application, and the whole process they wanted. And ultimately, we saw this liquidation terminated within 16 days, so just over 2 weeks, which in my memory is the fastest that I've ever seen one. The director really got onto proper advice at that point. Unfortunately for the director, the $11,000 turned into $63,000 because you've got to pay the $11,000 and then all those other costs that I talked about, your own lawyers, the petitioning creditors cost, the liquidators cost, the liquidators, lawyers costs along the process. So the director ultimately managed to get his company back within just over 2 weeks, but it's cost him what's 6 times the amount of money than if he just paid the $11,000 in the first place. So some things for clients that come to you and say, "Oh my gosh, my company's in liquidation and it shouldn't be. What do I do?" First thing is you can't just pay the original debt and hope that it will all go away. You need to get onto some good advice and you need to get into the court ASAP, and your client needs to accept that it's going to cost a lot more money, or a reasonable amount more money than ultimately what you owe. So some things to think about there. As a little postscript to this story, as I said, the director had maintained that didn't owe the Office of State Revenue any money at all, that hadn't worked in Victoria for some period of time. So after the liquidation has been terminated, the director filed all of the returns that he hadn't filed or the company hadn't filed, including the final return. And that's how the debt had come about. OSR just default assessed him and came up with $11,000. So the director went and filed all those returns in the final return and ultimately actually got a refund of the $11,000 back from the OSR. So could have saved himself a hell of a lot of heartache and a hell of a lot of money if he just filled out those returns in the first place. Okay, director penalty notices and repayment plans. It's another construction related company. But look, director penalty notice is a bit of the talk of the town. I think what we've had about 50,000 issued by the tax office in the last 18 months, and they don't seem to be slowing down in terms of issuing these director penalty notices, which for those that don't know is really the mechanism for which company taxes can be moved across to the directors personally. So the directors become liable for GST, PAYG, and superannuation. Okie doke. So it's a story about, as I said, a builder who got a little bit behind in the PAYG and superannuation. You'll see shortly that a little bit is actually a large bit. The tax office has issued a director penalty notice. They tend to be doing those when they have what they call a disengaged taxpayer. So someone that's not responding to their demands. They have some great letters with different colours on the letters that the colours get increasingly dark as they go along, ultimately ending in a red notice. If you're not responding to the red notice, you're really disengaged. And the tax office really seems to be using these director penalty notices to focus the director's attention on dealing with this issue. Director penalty notice is issued. Builder immediately contacts the accountant to say, I've got the director penalty notice, which in this story is actually one of the sort of more surprising and great things that the director did, because the director penalty notices are sent to the director at their home address as recorded on the ASIC's search. The director penalty notices are not sent immediately to the accountant or the tax agent at the time that they're issued. I'm on a committee with the chartered accountants, and we approach the tax department and ask them, well, when you issue these direct penalty notices, can you send them to the tax agent? The response from the tax office was, well, there's nothing in the law prohibiting us from doing that, but it's not part of our ordinary process, and we don't currently have any intention of making it part of our ordinary process. So we're going through, and we're going to continue to be in a system where the director penalty notice is being sent to the director. And for the accountants and on the webinar will know, in a lot of cases, director just goes, oh, another tax notice. My accountant will know about that. I'll ignore it and leave it from there. This builder didn't do that. He actually contacted his accountant. That we see the tax office is now trying to link the director penalty liability to the director's individual tax portal, so like through the MyGov. So we do have some directors that are contacting us that maybe not have received the notice physically because it's still floating around in Australia Post, but have seen their liability on their ATO personal portal or through the MyGov. So the tax office is trying to make the director a little bit aware of what's going on. But that's not directly to the accountants. That's not to say as accountants you can't call the tax office once you become aware of one and ask for them. The tax office is very happy to forward out to them, but you as accountants are not going to get them directly. Anyway, builder contacts accountant, got this director penalty notice. I want to put up a repayment plan to the tax office. And so hastily gets together a bunch of information and within the 21-day period gets a repayment plan approved by the tax office, which in itself is a bit of a record time frame. Now, the tax office tell us that if you're in a repayment plan that you're adhering to, then they're not going to pursue under the director penalty notices. But what you and your client should be aware of is that a repayment plan is not one of the options to remit a non-lockdown director penalty notice. Now, I'm not going to really go into the director penalty regime in detail. That'll take an hour just in itself to explain. But there are two types of notices. One where the director or where the tax office can pursue the director personally, and no amount of putting your company into administration is going to save you. That's called a lockdown notice. And then there's a non-lockdown notice, which gives the director 21 days to pay the debt or put the company into some sort of external administration. And if you do that within the 21 days, or in fact, before even the notice is issued, then the personal liability doesn't get onto the director, or more correctly, the tax office's ability to pursue the director personally isn't triggered. But the repayment plan is not one of them. You may get a repayment plan, as this builder did, inside of the 21 days, and you may be paying it, and the tax office may not be pursuing, but the 21 days will tick by. So if you fail on the repayment plan, as this builder did, then the 21 days is ticked by, and the tax office can now pursue the director personally. In this case, that's, as I said, what happened. The company ultimately failed and went into liquidation owing creditors about $5.8 million. So a fair amount of money. We weren't the liquidators. We actually were the bankruptcy trustees of Bob the builder. Bob went bankrupt because he had an expired director penalty notice, but he also owed income tax of $2.2 million, and there were other trade creditors, mostly personal guarantees from the failure of the company, about $660,000. So Bob owes a fair amount of money out there, $3.5 million he ends up owing, and he goes bankrupt of that. A bankrupt is required to complete some forms to tell us about their affairs. And Bob said he only had $3,200 to his name. He owed $3.5 million, but he only had $3,200. He did disclose that in the 8 months prior to his bankruptcy, he'd sold a boat, a car, and a house. So he had liquidated some assets, all in an effort to sort of save things. Okay. So court appointment, so like the liquidation that I talked about earlier, we're trying to gather information. And Bob was like relatively helpful, answered the questions. As you'll find out, the answers weren't necessarily what we wanted, but anyway, he answered. We did some investigations. Well, when Bob said a house, he really meant two houses. Two houses have been sold. And you can see the numbers up there on the screen. And Bob said, well, I didn't receive any money from the sale of those. We managed to get the settlement statements and the check directions. And that's correct. Actually, Bob didn't receive a check. The money went to the mortgagee. It went to some caviators who had personal guarantees. And some money went to Bob's mum. Now, Bob's mum lived overseas. We didn't have Bob's mum's contact details, or we saw that was some money went to Bob's mum. So we asked Bob for contact details so that we could contact mum, and asked also why Bob had paid some money to his mum. Well, Bob replied with he was trying to get his mum's approval to give us her contact details, and that he paid her because he owed her some money from there. So he's answered the question, but not really given us very much information at all. Bob did have a boat. He didn't have a boat anymore. Well, I've always wondered why he had a boat, because he lived in sort of the country and there was no lake, no river, no anything nearby. But anyway, Bob sort of had a boat. Bob had 3 cars. Okay, not just one car, admittedly over a little sort of period of time. And they weren't little cars. They weren't your Hilux Ute sort of building sort of cars. He had a Ferrari, a Mercedes, and a Lamborghini. So not entirely sure where the ladder went on the Lamborghini. But anyway, Bob felt that he needed to have these sorts of cars. And we do a lot of Googling to find out information about people. And it turns out that Bob had a little bit of a bingle in his Lamborghini. Now, look, a car crash is always, it's not really something that we wish upon anybody. But I must say that a light little bingle with a Lamborghini as you're driving down the street, I'm sure most of us have a little bit of a smile on our faces. Someone in a supercar has sort of crashed it. It turns out Bob was one Sunday morning on his way to a wedding in the Lamborghini that had the sort of a white ribbon on the car, and there was a little bit of a crash into the to the side barrier. Now, there's 2 reports on what happened. Ultimately, Bob is charged by the police for negligent driving. But the stories that came out of the people that were around at the time was there was the story from all of those people attending the wedding with Bob. It wasn't Bob's wedding, he was just attending the wedding. That said, oh, look, Bob was just driving along sedately, not doing anything particularly radical. And then look, the car in front of Bob stopped suddenly. Bob had to swerve, and unfortunately, he sort of crashed the car. So all rather innocent, and it said truly was an accident. Well, that was one version of the events. Then there was the other version of events for everybody else that was caught in the traffic jam, who wasn't going to the wedding. And their version of the events was that there was not just the Lamborghini, but there was also a Ferrari screaming through the street, dodging through traffic with high-pitched whining noises. And then Bob, perhaps a little bit out of his depth, manages to spin the car and crash it into the side barrier. Nobody got injured, thank gosh. But the report from the independent witnesses, let's say, was that yeah, it wasn't as sedate as what is being suggested. The police took the view of the independent witnesses, as I said, charged Bob. Bob ultimately went to court and defended the matter on the basis, well, no, this is the real version of the events. Ultimately, the matter was dismissed on the basis that, well, the judges said things like nobody bothered to test whether the brakes had failed or something of that nature. So they all agreed that there really was a lack of evidence, and so the charges were thrown out. So Bob ultimately has a Lamborghini with a few little dings in it from there. Right. Well, we're saying to Bob, okay, so what sort of happened to the boat and all of these cars that you have? Well, Bob's boat was under finance. And I must admit, I've seen this before, and I always think it's rather strange. The boat is still registered in Bob's name. The finance is still in Bob's name. But he's got some mate who said, "Oh, well, I'll have the boat." And then the mate is just continuing to make the finance payments on the boat and presumably driving the boat around from there. Never quite know what happens in the end. Like in our circumstance here, we got the finance payout, we got the value of the boat, and there really was no equity in it. So we didn't sort of really care what the friend had sort of deal the friend had, because there's nothing that we could sort of get out of it. But like the friend's paying for a boat in somebody else's name, what like if I don't know how he ever gets the boat into his name. But anyway, that was his problem from there. We asked about the Ferrari, and Bob said, "Oh, look, I sold that ages ago. I can't remember what sort of happened to it. I don't particularly have any records, but look, the company's in liquidation. Maybe the records are over with the liquidator. Go and have a look." The Lamborghini, apparently, he sold to a supplier that he owed some money to in the company's name. In return, effectively, the Lamborghini was to pay off that supplier's debt. I owe you 100 grand. Look, I don't have 100 grand, but here, take my Lamborghini. Again, Bob said, look, I don't have any records, but they'll all be with the liquidator. Go into the liquidator. They've got like a few boxes there you can go through and you can sort of find the record. And in respect of the Mercedes, he said he sold the Mercedes, definitely remember selling it. And I definitely remember putting all of the money into the company's bank account in an effort to try and save the company. Again, records with liquidator, go chat to them. So you can see that Bob is like provided answers, but they're not really helpful answers. They require us to go searching through a whole bunch of records to find the answers, to find out exactly whether what Bob was saying was the truth or not. And certainly we're still no further advanced in respect of this money that Mum's received. Now, every bankrupt can travel inside Australia all they want. But if you want to travel overseas, then you need the permission of your trustee to travel. Okay. It's not really a big deal. It's like a big stick. Okay. And it's actually quite difficult for trustees to prevent a bankrupt from traveling overseas. We've really got to have some evidence or some reasonable suspicions that something's sort of wrong, or that the bankrupt's not really helping you to prevent them. Now, Bob had provided answers to the questions that we'd asked. Not the best answers, but he had provided answers. And really, the bankruptcy was in this sort of state of flux at this time. There weren't any funds in the bankruptcy to advance investigations. And we were talking to creditors about whether they're prepared to fund some sort of review. And in that period of time, Bob asked to go overseas to see his mother. Apparently, she was ill and he went over regularly to see her and he sort of wanted to go. So faced with the position that we're at, we really had no choice but to let Bob go. And apparently, which was only going to be a few-week trip over to see his mum. Well, Bob's never come back. And we've lost contact with Bob. So I'm afraid I'm going to leave you with a story where I don't actually know what happened to the money from the Lamborghini, the Ferrari, or the Mercedes, because Bob's overseas and Bob doesn't seem to be coming back anytime in the near future. But really, the point of the story that I wanted to impress upon you is about these director penalty notices and repayment plans. They may stop the tax office from taking action while the repayment plan is going on, but they don't stop the 21 days ticking in a non-lockdown director penalty notice. So your clients need to be aware, and you should be aware as the accountant, is that if it all goes bad, then the director could be personally facing a fairly hefty claim by the tax office. So you should be making your client aware. Now, also going to my point that the tax office doesn't let the tax agent know about the director penalty notice unless you particularly contact them, or unless you have access to the director's personal tax portal. So if you have a client company and the director, and you know that the company owes superannuation or PAYG or GST, then keep your eye on the director's personal portal, because it may show up that there's this director penalty. And at that point, you can ask the tax office for the actual director penalty notice and then take steps to sort of deal with it from there. If you're only the director's personal tax agent and you see a director penalty liability on the director's personal portal, you should inform your client. Don't just assume that they know. The tax office, all they have to do is send it to your client by ordinary Australian post, so the director may or not have received it. Or the director may have received it and assumed that the accountant for the company is dealing with the issue, but the accountant for the company doesn't know about it whatsoever at all. So you see it as fast as you can, let the director know, and perhaps get a copy of the director penalty notice. What it just appears on the portal appears to be the liability, not the actual notices themselves. But as I say, tax office is quite happy to provide them to you. Okie doke. Needle in a haystack. And it's an accountant's attempt to provide some sort of tricky marketing title. And I'm the accountant that wrote all those. Now, I'll just pause at the moment because I'm getting some questions sort of sent through to me. And so before I get onto the story, I might as well go onto that. In respect of the first case study where the accountant was sued, I had a question about, was the accountant covered by insurance? Unfortunately, I don't know the answer to that question. We're the liquidators for the company. We didn't sort of see behind the scenes in respect of whether the accountant or the accountant's firm paid out personally, or whether they managed to get some sort of cover on professional indemnity. So can't note that. And then in Bob's case study, how can anyone in this position be allowed to travel outside the country? Surely their visa should be flagged. Okay, so I'll just go back to that point. So the question is really about bankruptcy trustees and allowing people to travel. The Bankruptcy Act itself actually says that as a bankrupt, you're required to deliver up your passport. Turns out that the law hasn't kept up with the reality of life, in that apparently passports aren't owned by us as individuals, they're owned by the government. So you can't actually prosecute, or certainly the regulatory body that will report offences to can't prosecute anybody for not delivering up their passport. But trustees can do an alert with the Australian Federal Police to prevent people from going overseas. So what happens is we do the alert, and when you go through the immigration process, it flags, and at that point, if the bankruptcy trustee has an alert on you, the Australian Federal Police will sort of come and tap you on the shoulder and take you into another room and then make contact with us to see whether we give you permission. In the old days, when our computer systems weren't so sophisticated, you used to actually get through immigration because there was sort of nothing to be flagged. Of course, now you're in the foyer area before you're getting on the plane. No, the Australian Federal Police don't know where you're sitting, which coffee shop you're drinking at, or where you're sort of sitting. So they used to wait until you're actually on the plane, sitting in your seat, because of course you've got to take your assigned seat. And then two federal police guys would come onto the plane with their guns and things like that, and walk up to you and tap you on the shoulder and go, "Look, excuse me, are you Jason Bettles?" "Yes." "Well, sir, like, you have to get off the plane." And then somebody has to find your luggage and remove your luggage. But it's a little more sophisticated now. The big issue, and that's really where the question is, yes, we can flag the visa, but then there's been some cases where bankruptcy trustees have refused to let somebody travel, and then the bankrupt has the right to effectively appeal that in a court process. And so then the court looks at it and goes, okay, what is the impact on the bankrupt estate? If the person is traveling overseas for work and is going to make income, well, that's actually probably to benefit to the bankrupt estate, because that may make your income high enough that you then liable to pay income under the income contribution regime. In Bob's case, he had answered the questions, and we were, as I say, in this state of flux. We weren't really doing anything further other than saying to creditors, we don't have any money. Does anybody want to advance that? So we didn't really have a grounds to say, well, Bob, you're not answering the questions. We require you to go down to the liquidator's office and try and find these records. So it really wasn't a grounds to stop Bob going overseas. Seems quite crazy, I know, but unfortunately, sort of how the position is in respect of the law. Okay, moving on to our story. Rightio. This is about Dean and Teresa. Dean ran quite a successful business, was getting sort of towards his retirement years, and decides that he's going to sell the business. And they bought a caravan and a new four-wheel drive, and Dean and Teresa were going to hop in the caravan and travel around Australia, do the lap from there. So 7 years prior to the bankruptcy, Dean sells the business. He sells it to some up and coming workers inside the business, and sells it on a vendor finance styles terms. The important thing was that Dean was his business and he created it, and whilst it was in a company structure and he sold the business from outside the company, he'd signed personal guarantees for various suppliers, some of the large suppliers that they had. And when he sold the business, he didn't get removed from those personal guarantees. Like, this is a story that we see, not a lot, but we certainly see it. And it's a combination of the director not realizing that just because you resign as a director doesn't mean the personal guarantees go away. And two, in some circumstances, the suppliers won't remove your name from the personal guarantee. In this case, it seemed that happened a bit, that they saw Dean as sort of the founder. They didn't know these sort of new guys. Happy to give them COD, but certainly wasn't going to give them credit in the near term. And so they needed credit. And so Bob remained as a personal guarantor for a number of the supply accounts. Bob, though, did get an indemnity from the purchasers of the business from these young guys. So he basically said, look, something goes wrong and I get demand under the personal guarantees, then you agree to pay those bills from there. An indemnity that seems great on paper, but as you'll find out, really sort of is worthless. Okay, so it's 7 years ago. Business has been sold. Dean is still on for the personal guarantees. Dean and Teresa have bought a caravan, hopped in it, and traveled around the country. Now, turns out Dean and Teresa are a lovely couple, but aren't designed to live in a 19-foot caravan for an extended period of time. And the trip around the lap didn't go as well as they'd hoped. This is the story that we're sort of told. And the trip is cut short, and Dean and Teresa are sort of back. They end up seeing lawyers and sign a binding financial agreement to split the assets between the two because the marriage is apparently on the rocks. Okay. So that's happened 6 years previously. I'll come to now because we're involved because Dean has ultimately ended up bankrupt. Okay. And he ended up bankrupt because the purchase of the business didn't work out as well as they thought. The business ultimately failed. Those two young guys ended up going bankrupt themselves. So when Dean got calls under the personal guarantees, and he went, oh, well, okay, guys, you signed this indemnity. They said, we're bankrupt, lodge a claim with the bankruptcy trustee. So Dean didn't get any money at all, had these big claims, and he ultimately ended up bankrupt. Okay. But let's just go back a little bit to that binding financial agreement. Remember, this is 6 years prior to the bankruptcy, a year after the sale of the business. They've split up the assets, and you can see the two major keys in there is that the house, the marital home, goes to Teresa, and the company, the shares in their company go to Dean. So you look at those numbers and you go, well, okay, Dean got a better deal out of that. If anybody got ripped off, it's Teresa. Okay. But it's all really essentially around these shares in the company. Okay. Today, when Dean is bankrupt, he's still living in the same house with Teresa. So they're sort of still together. But of course, the company has failed. So you take out the $2.1 million and you go, whoa, this is heavily in Teresa's favor. maybe something is wrong with the binding financial agreement. But it's 6 years earlier that they sold it. Oh, sorry, that they signed it. There's a few provisions under the Bankruptcy Act where bankruptcy trustees can overturn transactions that are to the detriment, basically, of the creditors and to the bankrupt. There's undervalued transactions, so simply the sale of the asset or the transfer of the asset was for consideration less than whatever the value of the asset was. Okay, it used to be that you could claim, oh, natural love and affection, it's my husband and wife, and so I can transfer, and that's the consideration. They've written out those out of the Act. There's no value in those things at all. There's some slight different timeframes between related parties and non-related parties in respect of showing insolvency. But generally, if you can only go back 4 years for related parties without having to prove that the bankrupt was insolvent at the time. So you see our problem here is 4 years. Even if we could get to the 5 years, it's still short of the 6 years. So that provision doesn't work. There is the transfers to defeat creditors, and there's no time limit on that. But the trustee must prove that the main purpose was to prevent the property from becoming divisible. Okay, we rarely find in the records of everybody the one little note that says, oh, I'm transferring the house to my wife so that my creditors don't get it. And if you're used to writing that in your notes, I suggest you stop writing that, because then if we've got something like that, then we can show, well, there was some intention to keep the assets away from there. We can infer the intention if the bankrupt was insolvent at the time. So in this circumstances, we've got to go back 6 years and to try and prove that Dean was insolvent at this time of the transfer, which from the numbers that I showed you, he wasn't insolvent. The business was going along fine, seemingly at that point in time. We did, however, require records from everybody around the binding financial agreement. We asked for the advices that each of the parties received and some of the documents. Now, they each had separate lawyers. The documents that came back from Teresa's lawyers were all seemingly sort of relatively innocent. And then, but it was at the back of one of the documents, this advice that Teresa had got about 5 years ago. So we're another year now after the signing of the binding financial agreement. And you can see the advice centers around keeping the bank at bay if Dean faces some financial problems, and some suggestion that by doing this, you're preventing further action by the bank. By transferring this asset across to Teresa, you're preventing further action from the bank. Now, it's not necessarily that golden needle in the haystack, but look, it gets pretty close, and it's attached to the back. And it was enough for us to go, okay, let's have a chat to all of these people in front of the judge and under oath. So we called a public examination. Like the ones that are available in liquidation, bankruptcy trustees can do one. I mean, the process is slightly different, but the outcome is the same. Bankruptcy trustee trying to get some information about sort of what had happened. Dean mysteriously became very sick. He couldn't attend the public examination. He never attended the public examination and answered things under oath. Teresa did come to the examination as she was required to do and answer the questions that we put to her. And it was all relatively straightforward until we produced this legal advice and started asking Teresa some questions about it. And it became abundantly clear at that point that they didn't know that we'd had the advice, that it had unfortunately accidentally been stapled to the back of some other documents. Teresa tried to say, we shouldn't have it, that we can't use it. But of course, we had it by this point and we knew what it said from there. So we then proceeded to, well, we're about to file proceedings. We in fact wrote out to creditors and explained the position to them. Okay, this is what we're doing. or this is what we're thinking of doing. Our reports that go out to creditors also generally go out to the bankrupt or to the directors or the shareholders so they can see what we're writing. Um, and that prompted a proposal from Dean. It was called a Section 73 proposal. They're available to people who are bankrupt to get out of bankruptcy early. Creditors, I can stay through the bankruptcy. This is likely to be the return that you'll get, but I'm going to offer you some money. It generally has to be more than what you would get in the bankrupt. And if creditors accept it and you pay that, then your bankruptcy is annulled. So at law, it means you never were bankrupt. So Dean puts up the proposal that says, okay, I'm creditors, I'm going to offer you. It was about 17 cents in the dollar, I recall. So we write out to creditors again, okay, well, we can file these proceedings. We may ultimately win. We may ultimately get you a greater return, but it's litigation. We don't know what the answer is going to be. Dean's put up this proposal of this 17 cents in the dollar guaranteed return. And ultimately, it's up to creditors to just decide which option do you sort of take from there. Creditors sort of took the bird in the hand, so to speak, and ultimately said, yes, we'll take Dean's proposal, we'll take the guaranteed 17 cents, and he'll get out of bankruptcy, but at least we'll get some sort of return from there. So my top tips of advice as we sort of draw to a conclusion is lawyers, keep up the good advice. Advice was great. There's nothing wrong with it whatsoever at all. But everybody, you may just want to double check the documents that you're sending through to the bankruptcy trustees and the liquidators. Unfortunately, this is stapled to the back and clearly shouldn't have been stapled to the back. And maybe if we'd never seen it, then none of them, or Dean and Teresa wouldn't have had to pay out some money. So just double check those sort of documents as you send them through. Unfortunately, ladies and gentlemen, we've come to the end of the presentation. I've taken up your time for an hour. Thank you very much for listening now. So I can't get on to the final story. The slides, I understand, will be sent through to you. It is about story that we did a on the Pulse article about during the year. So feel free to have a look at that. If you've got any questions about it, as you sort of go through it, then please feel free to contact any one of the Worrells principals around the country who can sort of fill in the blanks between the slides, so to speak. Jordan tells me that we haven't had any more questions from anybody. So I suppose that's my opportunity. Thank you very, very much for attending our last presentation for the year. We're obviously very, very close to Christmas. So I hope you and your families have a great Christmas and a safe Christmas, a great new year, and we'll see you in 2025. Thank you very much.